So this panel is titled AI, Automation, and the Future of Work, Rethinking Federal Labor Standards. And we have the best of both worlds here today. We have an AI expert and a labor law expert. So this should be a fun panel, and I'm personally very excited for this. So our first speaker is Professor Kevin Frazier. Professor Frazier received his BS from the University of Oregon and an MPA from Harvard University, and his JD from the University of California, Berkeley. He's traveled all the way from Austin, Texas to be with us today, so we're very grateful for that. Professor Frazier is the inaugural AI Innovation and Law Fellow at the University of Texas at Austin School of Law. Professor Frazier's research centers around artificial intelligence, innovation policy, and regulatory design. He co-hosts Scaling Laws, a podcast on AI policy, and contributes to Lawfare, a multimedia publication that provides nonpartisan, timely analysis as a senior editor there. Professor Frazier's forthcoming article with the West Virginia Law Review is titled, A Practical Reason in the Portfolio Economy, Accept, Amend, or Abandon the FSLA, which examines the Fair Labor Standards Act and how AI might test its durability. Our second panelist is Professor Ann Lofaso from the University of Cincinnati College of Law. However, I'm more proud to introduce her today as the Arthur B. Hodges Professor Emerita at the WVU College of Law. Professor Lofaso was my labor law professor last year, so it's very exciting to welcome her back for this talk. Professor Lofaso received her AB from Harvard University and her JD from the University of Pennsylvania Carey School of Law, and her doctorate in philosophy from the University of Oxford, where my favorite fun fact is she attended alongside Justice Gorsuch on the Supreme Court, so that's pretty cool. She is nationally recognized as a labor law expert and has authored over 70 law review articles in the field. Professor Lofaso will bring her expertise in labor law to discuss how it should move forward in the face of AI and comment on Professor Frazier's article. We're very excited for this panel, so join me in giving them a warm welcome, and we'll invite Professor Frazier up to the podium.
All right. Well, thank you so much for having me. It's a pleasure to be here. I'm not sure who Amy was referring to in terms of rock stars. There's a common saying that those who can't do podcast, and that applies to me, but I am very glad to be here. Huge thanks to George, Zach, and Alan for all their hard work. And just this warm welcome has been so exciting. As a podcaster and a lecturer, I am prone to go over my time limit. So if you see me staring at the clock, it's only because I want to respect the panel setup and make sure we have time for questions. But really, I want to start off by saying one quick thing in response to Professor Fairfield, which is he is very bright, he's very smart, and I would encourage you all to test the tools for yourselves and also check out tools like Harvey. Harvey boosts an incredibly low hallucination rate for the practice of law itself. There's also a tool called Learned Hand that's being used by the LA Superior Court right now for the practice of law. So this is a court in California adopting an AI tool to help with writing legal opinions. I'll let you decide if what California does is a good or bad model. That's up to you. But just know that there are courts around the country who are testing and trusting AI to write these opinions. So if you have a chance to go dabble with Harvey or Learned Hand or other bespoke AI legal tools, I would encourage you to do so. Now, I'm going to talk about something that's far less exciting than AI hallucinations and whether or not we're developing unhealthy relationships with AI, and talk about the Fair Labor Standards Act, which I'm guessing none of you woke up this morning thinking, by golly, the FLSA, you can't even say it. I can't wait to talk about that. So why the heck should you care about it? Well, the FSLA was devised at a similar period of time in which we're facing right now, which is to say we were experiencing a transformation in our economy and what we thought of the meaning of work itself. So we're coming out of the Great Depression, we're entering the 1930s, and we've got some real problems going on. We've got child labor, for example, is still a thing in the US. We have incredibly excessive hours going on that are being worked by folks across different industries. And we also see that there's limited clarity and specificity with respect to workplace protections. And really the central issue that we were devising and trying to answer was, who is an employee, who is a contractor, and who's a professional. So these were all central components that we saw Congress and President Roosevelt trying to answer. Now, the original aspiration for the FSLA was a sort of flexible, industry-driven approach to determining what should wages look like for a specific industry and what should hours look like for a specific industry. Well, Congress did what Congress usually does and turned an aspiration into something that was dictated by some different controlling interests, some different special interests, and we got a bill that didn't look exactly like the president wanted. Instead, what we saw was something that was incredibly rigid, that had a few carve-outs for very special professions and very special industries. Still, there was early hope that the FSLA was going to be implemented in a robust and flexible fashion. There was hope, for example, that it would lead to a sort of cooperative enforcement mechanism that would be responsive to changes in industry, and that there would be regular advisory opinions from the Department of Labor about how to interpret the FSLA as the economy shifted. In turn, what we saw instead was a rigid enforcement system in which this Byzantine question of are you an employee, are you a professional, or are you a contractor became something that was just highly litigated that often didn't serve the interests of the workers themselves. And so we've continued to lean on this model of are you an employee, are you a professional, or are you a contractor since 1930. Now my hunch is that we all agree that the economy has changed quite a bit since 1930, right? We have seen new changes in how we work, how we want to work, the mechanisms we use, the tools we use, and yet we're still leaning on the Fair Labor Standards Act. So as we know that AI is changing the economy, we're left with a question. Should Congress amend the FSLA? Should they just allow it to stay in place, or should we envision something different? And what I'm going to call for is a move to envision something different. And if you're wildly bored right now, first, I apologize. Second, I think you should still care because whatever the issues are with the FSLA, it's a story that we see across different pieces of regulation right now, which is they were devised in a bygone era, very well-intentioned, and yet they're now running up against a very different economy and a very different set of cultural norms and political norms. And so how do we go about this practice of reimagining regulation? All right, so why do we even need to begin this exercise? Well, I think that we are entering what I like to refer to as the portfolio economy. So the portfolio economy is what we're going to all experience, especially you, Gen Z, Gen Alpha, and if there are any babies in here, Gen Beta, members of the American population. We're all going to experience this portfolio economy. What the heck does that mean? So with AI, you all have probably all heard of the fact that we're now dealing with a kind of task-based approach to hiring and working, right? As AI starts to automate or augment certain tasks, we're seeing that our jobs are being defined more and more by discrete individual tasks that you perform. So in that regard, if you're really good at a bespoke task, if you are the best at that thing, that is a very marketable skill for you to go out and perform. But if you're the person who wakes up in the morning and you say, I am the best at writing emails, I'm not sure you should hang your hat on that one, right? That's going to disappear along with the dodo bird. So we see this task-based hiring approach. We also see this great fissuring of the economy. And this is what David Weil originally identified. We're seeing massive corporations, think Google, think any Fortune 500 company. And what they're doing is they're taking more and more of their day-to-day operations. And if it is not core to their business, they're subcontracting that out, right? So whereas you maybe used to have some degree of a security team, for example, actually being Alphabet employees, that's no longer the case. You are seeing more and more companies outsource anything that is not core to their business. Why are they doing that? That fosters competition, right? You can easily swap out security firm A for security firm B. And so the net result of these two trends, seeing work become more task-based and seeing more firms rely on this fissuring approach, separating work out to more and more contractors, is this portfolio economy in which you and me and all Americans for a long time are going to have to learn more skills, apply those skills to more and more businesses. Gone are the day when you worked for 30 years for a single company, got a pension, and then got a really cool watch. That's just not the economy we live in. We live in this portfolio economy. And so if that is the case, does the FSLA align with this new portfolio economy? And my argument is no. All of us are going to have to learn more skills more quickly, offer them to more employees on a shorter term basis, and complete that cycle faster and faster. Now you may be thinking, this is the most dystopian thing I've ever heard in my life. You've just told me that we're basically all becoming gig workers. That is one outcome, right? And that's an outcome that I don't want to see happen either. I don't think anyone wants to see that sort of feeling that you're constantly being hurried to find a new employer, offer new tasks, and you never have that sort of sense of stability and opportunity. That's why I think we need to dare to dream, what could this look like in a positive sense? How can we make this portfolio economy something that is actually beneficial to all of us? I don't think we get to those benefits unless we amend or really opt out of the FSLA. So here's what the utopian story could look like, right? Imagine a world in which you had better access to childcare, where more workers could more easily find companies that supported and sustained childcare options. What if you had more PTO? What if you had more control over working extra hours one week and then not working additional hours the next week? What if we had a world in which there was reduced reliance on credentials? Now, I don't know the tuition of WVU, you don't have to tell me, but you may have seen that Georgetown University recently announced that their tuition is going to be $95,000 per year. That is absolutely bonkers. Now, regardless of what Professor Fairfield said, I do believe that AI is an incredible tutor, and if you want to learn a new skill, you can do so for a heck of a lot less than $400,000 over 4 years, right? So if we can imagine an economy in which having that credential, that paper diploma, isn't as valued, but instead we're really leaning into, do you know this skill or not? To me, that's a sort of utopian tale. That's something we should celebrate. We can also imagine more and more folks, commonly referred to as stars, this is skilled through alternative routes, having more means to earn jobs for which they are highly competent, right? As a result of moving into this portfolio economy. So how the heck do we get there? If we're not going to lean into the FSLA, because the FSLA's rigidity of saying you are either an employee or you're not. You are either a contractor or you're not. You're either a professional or you're not. That sort of rigidity does not work in the portfolio economy. So what should we instead focus on? Number one, I think we need to focus on optionality. This would allow for firms to offer a menu of different benefits upon which they then compete, right? So you could imagine Google saying that, hey, because our preferred workers tend to be a little bit older, we know that childcare is an incredible importance to them, and we know that PTO is of incredible importance to them. So maybe that's their benefit package. Now, on the other hand, you may have Snap. They're saying, we want those creative influencers, we want those young folks, we want Gen Z to be our next employees. Maybe childcare isn't as much of a priority. So instead, they're going to boost up the pay, right? And say, we're going to offer you more money. Rather than dictating explicitly for each worker what benefits must you be guaranteed, let's allow for competition across the benefit spectrum. And so now you get to decide, you have more agency as a worker of saying whose employer benefits align with my own preferences. Second, we need to live in a world of portable benefits. Right now, a lot of your benefits are tied up with your employer, right? You earn your 401k, oftentimes through your employer themselves. I'm sure WVU is sending money into a very specific account. Guess what? You leave WVU, and then you just get this annoying letter for the rest of your life that says, oh, by the way, you have this money sitting in this account. And you're like, okay, am I ever going to access that? I don't know. It's just kind of sitting there. That doesn't help anyone. We need portable benefits. We need to see a world in which you can take the time you've accrued for time off, for example, move across employers. This has been something we've been asking for and advocating for a long time. You've seen, for example, Uber drivers, Lyft drivers say they want portable benefits. This is the moment where we can really advocate for that. Third, we need what I like to call, for those Gen Zers or folks who watch, Love Island, we need DTR. We need to define the relationship, right? And defining the relationship here means instead of the law dictating, you must regard yourself as an employee or you must regard yourself as a contractor, make that a part of the negotiation process as a potential employee. If you want to be defined as a contractor, specify that from the outset of the employment agreement, right? And make sure everyone's on clear terms such that we get ahead of this endless cycle of litigation that we're seeing with respect to the FSLA. So this approach of moving into a more flexible, iterative model, I think is going to allow us to better thrive and adjust to the fact that the economy is shifting in rapid fashion. Now, more generally, I think we need to apply this model of thinking about regulation across the board. If you are sitting here today and you are thinking, especially after the first presentation, I am wildly pessimistic about AI. I totally get it, and I totally hear you because it is wildly disruptive, and I would also agree with a lot of folks who feel like AI kind of sucks. It gets a lot of things wrong. It doesn't feel as though it's being used to actually advance general welfare. It doesn't feel as though it's being responsive to our needs and our wants. If you are in that position, especially if you are among the younger folks here who are going to graduate and go into jobs, go and become clerks, go and become members of the West Virginia government, or go and even lobby DC, this is your moment. And I'm not trying to sound too Pollyannish or too paternalistic, but really seize this moment, because if you want to build better AI, if you want AI to go well, it's not just going to happen by happenstance. And my fear is that by virtue of us as lawyers generally having a sense that the status quo is good enough, or the status quo is something that we can slowly tinker with, we're going to find ourselves locked into a very bad future. The FSLA was something that was written multiple decades ago. We need to have the courage to be able to experiment and say, can we envision a different way of working and laboring and defining our labor classifications? Now, this isn't going to be easy. So if you vehemently disagree with my ideas around optionality, portability, and defining the relationship, awesome. I want that to happen. I'm betting that I'm wrong. And I think what we need to adopt is a sense of iterative regulation that we have not seen across the US for a very long time. There's a movement growing now that I hope to see spread further around dynamic legislation. As Professor Fairfield lined out, we don't know exactly what the future is going to hold. And yet when we see a law get written on the books, most of them are what I call zombie laws. They're not going anywhere, right? They are going to sit on the books for a very, very long time. It is incredibly difficult to get even the worst laws off the books. I'm living this right now in Austin, Texas, because I am a horrible attendee of any football party on a Sunday. Why? Because I can't buy booze before 12 p.m. on a Sunday. And I always forget that I was supposed to bring a six-pack to my friend's house. Why do we still have this law? There's no good reason, right? We will see this continue to compound and lock us into a technologically bygone era unless we acknowledge an iterative approach to legislation. And so something that I just want to call attention to as you all are thinking about these questions is how can we make the law less static? This is a huge challenge that all of us face. A couple different things that I just want to call attention to, and then I look forward to receiving some feedback. First and foremost, sunset clauses. We can make sunset clauses a part of every single law. If you think you're so smart that you know the future of AI and how it's going to impact the rest of the economy, please go work for Meta or Google or OpenAI and go make $100 million because they'll pay you that much if you know everything that's going to happen with respect to AI. But my hunch is that we need to practice far more regulatory humility and admit that our laws are probably going to be technologically obsolete sooner rather than later. So first, let's lean on sunset clauses. Second, let's lean on retrospective review. For the folks who think they got their law right, got their proposals correct, prove it with data. It's amazing how many times we see a law get passed, sit there, and then no one knows how to actually hold those legislators accountable because we haven't specified what metrics we're going to use to actually assess whether that law worked as intended. So with respect to the FSLA, for example, let's measure and see, are we seeing the hallmarks of a more dynamic economy? Are we seeing folks who are able to switch jobs more easily? Are we seeing people be able to move to communities where there are more job opportunities? These are metrics that we can measure and review and assess legislation against. And yet we just have a failure of imagination and investment when it comes to doing law better. So this is a part of a much broader project. I think that starting with the FSLA and beginning to reimagine how we treat labor law is incredibly important. But knowing that I have not written 70 law review articles, I am very eager to receive some feedback. So thank you all for your attention, and also happy to take questions after the fact.
Right. So I am definitely not the rock star here. I am not an AI expert, although I have a strong interest in AI. I've been following it for many, many years, well over a decade. And of course, most people understand that AI and labor, there's always a trade-off, and that is a historical trade-off, that anytime there's a new technology, it's going to replace jobs, but displace jobs, but it's also going to create new jobs. But in any event, good morning, everyone, and thank you. I want to thank the West Virginia Law Review for inviting me and the symposium organizers for inviting me here today. I want to thank George and Zach and Alan in particular, and especially Zach, who has been taking my questions and has been wonderful. And I will say that I see my former dean in the back, and it's great to see her, and other people here. I see Nick back there, and it's really great to see everyone. And for those of my friends who didn't come today, I'm very annoyed with them, so please tell them I'm annoyed. I'm kidding, obviously. I did have tears in my eyes as I came back here, and I hope that you will invite me next year to your NIL conference. In any event, did I just screw up the surprise? Did I? Oh, no, I'm sorry. Okay. Anyway, I'm here to offer a social dignitary in response to Professor Frazier's diagnosis of what he calls the portfolio economy. We live in an increasingly polarized world, and the legal architecture that once protected workers is fraying under the pressures of outsourcing platforms and AI. My aim today is straightforward. I accept Professor Frazier's diagnosis that the workplace is changing, but I will argue that his remedy, centered on individualized agency and standardized disclosures, cannot by itself secure dignity, enforceable duties, or meaningful autonomy for our workers. Now, I just want to say, having said that, I think he's made an incredible and substantial contribution to the literature, and that his paper is excellent, excellent. However, it is my job as a senior faculty member to try to add to that and give my opinions. But these are just my opinions, and really, whether you agree with me or him, or both of us in some way, or neither in some way, really will depend on your values. So I propose a statutory and doctrinal alternative grounded in dignity, named duty holders, and collective power, so that portability and optionality deliver security rather than precarity. So here's my roadmap. First, I will briefly restate the shared diagnosis. The modern workplace is fracturing and producing a no-duty holder problem. Second, I will explain why Professor Frazier's emphasis on agency, standardized work relationship disclosures, and individual choice is insufficient both doctrinally and practically. Third, I will set out a social dignitarian framework built on 3 concrete rules: duty holder clarity, collective power, and regulated portability. Really not very different from what he says, but you'll see at the values level there are some differences. And finally, I will sketch a modular legislative architecture and pragmatic rollout steps. Let's start with the diagnosis. This is where we begin in agreement. The traditional long-term employer-employee relationship is fracturing. Lead firms outsource, franchise, and contract out work. Platforms mediate transactions, and AI fragments tasks into micro-assignments. The result is not merely administrative complexity. It is a structural mismatch between economic control and legal responsibility. When a lead firm designs the work, sets prices, and controls algorithms, but the labor is performed by subcontractors or independent providers, the law often cannot identify a single employer to hold accountable. Accordingly, there is often no single legal employer that the law can compel to pay wages, provide benefits, or ensure safety. That is the no-duty holder problem. And let me let you know that I do have an article on that you're welcome to cite in your article, okay? That was funny, wasn't that? No, you didn't get it. Okay, the academics loved it though, okay. All right, so this fragmentation procedure produces, three predictable harms. First, accountability gaps. Injured or underpaid workers face a maze of entities and inconsistent enforcement. Second, erosion of standards. Lead firms capture brand and revenue while shifting costs and risks to smaller subcontractors that compete on price, producing lower wages and weaker safety practices. And third, regulatory uncertainty. Courts and agencies struggle to apply employer-centric statutes like the FLSA, NLRA, and OSHA when economic reality is split across multiple firms. These are not technical glitches. They are structural failures that demand structural solutions. So you can see we actually agree on quite a bit. Now, I'm going to just summarize Professor Frazier's proposal and its strengths. I want to emphasize its strengths. So his proposal responds directly to these symptoms with three pillars: optionality, portability, and agency. Optionality decouples benefits from classification and establishes a statutory benefits floor that firms can offer across different menus. Portability creates individual security accounts, ESAs, I guess you would say, that follow workers across engagements. An agency replaces classifications litigation with standardized work relationship disclosures, allowing workers to see and choose their arrangements. These ideas have real strengths. Portability, in particular, advances the debate by insisting benefits follow the worker rather than the job. Optionality recognizes the need for a baseline of protections in a fluid labor market, and agency attempts to simplify a litigation-heavy classification regime. I accept this diagnosis and credit these contributions. But the central problem I will address is that agency, as conceived, treats formal disclosure as equivalent to meaningful choice, and that is where the model is less than I would like to see. Now, why agency is insufficient? I call it the illusion of formal consent. Formal consent is not the same as meaningful consent. Standardized disclosures assume that workers have the time, information, and bargaining power to evaluate complex terms and to negotiate or refuse them. But most workers face urgent income needs, limited information, and asymmetric bargaining power. Joseph Raz's account of autonomy helps us see why. Autonomy requires not only the absence of interference, but the capacity to be a part author of one's life, mental capacity, adequate information, independence from coercion, and meaningful participation. A signed disclosure form provides none of these guarantees. Historically, the Lochner era teaches the dangers of formalizing consent. In cases like Copage versus Kansas, the court treated contractual liberty as sacrosanct, even when the worker had no real bargaining power. The result was legal validation of exploitative practices. Frazier's work of WRDs risk reviving that illusion. They convert structural inequality into a veneer of consent. When a platform or lead firm offers a disclosure that says you are an independent contractor and the worker signs because they need the income, the law should not treat that signature as proof of meaningful autonomy. Practically, WRDs also fail enforcement tests. Who audits disclosures across complex subcontracting chains? Who enforces contribution obligations when lead firms disclaim responsibility? Optionality without collective enforcement invites a race to the bottom. Firms will compete on price by minimizing benefits, and the market will reward those who externalize labor costs. In short, agency without power is hollow. It treats labor as a factor of production rather than as human beings with dignity. So I'm going to now pivot to the moral grounds here, my social dignitarian principles. If market efficiency is the wrong foundation, what should guide us? I propose a social dignitarian framework grounded in natural human rights, chiefly dignity and autonomy. Drawing on Kant, dignity requires that we treat humanity always as at the same time as it ends and never merely as a means. Drawing on Rawls, I propose a veil of empathy. Policymakers should imagine choosing rules without knowing whether they will be a privileged consultant or a precarious gig worker. From that position, rational actors would not choose a system that leaves workers exposed to arbitrary dismissal, unpooled health risk, and fragmented enforcement. This moral pivot yields 3 design imperatives. First, duty holder clarity. The law must name who is responsible when economic control is exercised. Second, collective power. True autonomy requires collective bargaining and sectoral mechanisms that rebalance power. Third, regulated portability. Portability must preserve social insurance logic through pooling and public governance, not atomized individual accounts that leave workers bearing concentrated risk. So, concrete rule 1, duty holder clarity. The first statutory move is to redefine employer to capture economic control. Where a lead firm sets standards, controls prices, or dictates algorithms, it should be a joint duty holder for wages, benefits, and safety. This is not about punishing small subcontractors. It's about preventing upstream capital from capturing value while disclaiming responsibility. Mechanically, the statute would identify factors that trigger joint duty holder status, control over performance metrics, ownership or exclusive use of the platform, pricing authority, and algorithmic governance of work. Once those factors are present, pass-through liability would attach for wage and benefit obligations. This approach closes the ontological gap that allows firms to hide behind misclassification labels, and makes it unprofitable to design business models that externalize labor costs. Duty holder clarity also simplifies enforcement. Rather than litigating over whether a worker is an employee of firm A or firm B, regulators and courts just simply ask whether firm A exercised economic control that the statute deems sufficient to impose duties. That clarity reduces litigation, increases predictability, and aligns legal responsibility with economic reality. Concrete rule 2, collective power and sectoral bargaining. The second move restores collective power. Individual bargaining in a fragmented market is an illusion. We must facilitate sectoral bargaining, industry-wide negotiations that set wage and benefit floors across entire sectors where individual bargaining fails. Sectoral bargaining preserves the value of portability by ensuring that benefits are negotiated at scale and that ESAs or pooled funds reflect collective agreements. Legal protections must also explicitly protect organizing rights for platform and fissured workers. That means updating labor law to recognize collective representation in non-traditional workplaces, to protect concerted activity on platforms, and to enable works councils or sectoral boards where appropriate. Collective institutions provide workers with structural power necessary to make meaningful choices and to hold duty holders accountable. Sectoral bargaining also supports training and upskilling funds, industry risk pools for health coverage, and negotiated portability rules that preserve group bargaining benefits rather than atomizing them. Concrete rule 3, regulated portability and pooled ESAs. Portability is necessary but not sufficient. ESAs must be publicly regulated, transparent, and pooled. Left as individualized islands of risk, ESAs will leave older, sicker, or lower earning workers exposed. Instead, contributions should feed industry risk pools governed jointly by worker representatives and management with public oversight to ensure solvency and fairness. Health coverage, unemployment protection, training funds, and retirement contributions should be pooled at the sectoral level where feasible. ESAs can still record individual entitlements, but the underlying financing and risk management must be collective. This preserves the social insurance logic that makes healthcare coverage affordable and training scalable. Governance matters. Boards of pooled funds should include worker and employer representatives, as well as independent public trustees. Transparency, audit rights, and enforceable contribution rules are essential. Portability should mean that a worker's entitlement travels with them, as my colleague said, but pooled resources and collective bargaining outcomes should back those entitlements. Procedural protections and dignity at work now. Dignity requires procedural protections attached to work. Employment at will treats workers as disposable. Just cause protections and grievance mechanisms treats them as persons with standing. The statute should attach just cause dismissal protections and anti-retaliation safeguards to engagements that meet thresholds of duration or intensity. Workers should have access to grievance procedures with worker representation, expedited arbitration for disputes, and rehire protections where appropriate. Protecting the psychological and social value of work matters. As Lord Beveridge observed, job loss endangers self-respect. Procedural protections preserve the social meaning of work and reduce the arbitrary power of employers. They also make portability meaningful. A worker who can be arbitrarily dismissed without recourse cannot meaningfully carry a career forward. So what's my legislative architecture? So I'm going to translate these principles into a modular statute with 3 titles. Title 1 would be minimum rights, which establishes a universal floor, a living wage, safety standards, anti-retaliation, and just cause provisions. Title 2 would be regulated portability, which would set rules for ESAs, mandatory contributions, public governance, and a pooled risk. And then Title 3 would be duty holders and bargaining, imposes joint liability where economic control exists, and mandates the facilitation of sectoral bargaining and the establishment and enforcement mechanisms. Modularity, which sounds very much like you were talking about, actually. I'm thinking we're much more in agreement than I thought. So modularity allows phased implementation and targeted pilots. It also permits tiered rules to protect genuine small businesses and startups while preventing large firms from exploiting tiering as a loophole. The statute should include robust enforcement tools, administrative units with investigatory powers, civil penalties calibrated to deter evasion, and private rights of action with enhanced remedies. So how would we implement this? I would say with pilots, tiering, and enforcement. Again, something you really kind of started talking about. Implementation must be pragmatic. Start with phased pilots in highly fissured sectors like logistics, healthcare, and platform delivery, using evaluation metrics to refine rules. Use tiered contribution schedules and tax credits to protect small employers and national startups while ensuring large lead firms should shoulder appropriate obligations. Fund enforcement. Create a dedicated unit with the Department of Labor to oversee pooled funds, audit contributions, and enforce duty holder rules. Provide private rights of action with fee shifting and enhanced remedies to make enforcement accessible. Make misclassification and evasion unprofitable through calibrated penalties and joint liability that reaches upstream capital. Now, here are some anticipated objections and my reply. This burdens innovation. Tiered design and targeted subsidies protect genuine startups. We should not subsidize business models built on externalizing labor costs. Objection 2, this reduces worker choice. Choice without power is illusory. A rights floor and collective backing expand meaningful choice by protecting workers from coercion and catastrophic risk. Objection 3, enforcement is complex. Reply. Duty holder clarity simplifies litigation and enforcement by aligning legal responsibility with economic control. Pooled governance and administrative units make oversight feasible. So what are my doctrinal takeaways and what is the core conflict here? Doctrinally, fissuring and AI create a no duty holder gap that the current employer-centric statutes cannot fill. Professor Frazier's diagnosis is indispensable and portability is a valuable idea. But agency without power treats labor as a commodity and risks distributing wealth upward. The true conflict is distribution. How do we share the wealth jointly created by labor and capital? My answer centers on dignity, enforceable duty holders, and collective power so that the gains from AI and capital are broadly shared. This is my conclusion. Practical reason demands that the law correct power asymmetries rather than formalize them behind the illusion of contract. Pilot sectoral ESAs enact duty holder rules and strengthen organizing rights. Embed portability in pooled publicly governed funds and restore collective bargaining where individual bargaining fails. My goal is simple. Make portability and optionality deliver dignity, not precarity. I just want to thank you very much for listening, and I'd love to engage with you in conversation.
Thank you very much.
Thank you.
Well, we're running a little ahead of schedule, so Professor Frazier, if you would like, we have about 10 minutes if you want to respond to that or offer new ideas, and then we can open up to questions. If that
Yeah,
sounds good.
so I'm happy to initially respond and then happy to field as many questions as folks want. Given that I do teach AI in the law and get to cover just about every nexus of AI and different ideas, I'm open to questions kind of from right field or left field, whatever y'all want to talk about. My initial response is yes. This is great. This is exactly what I want, because I think that we are at a moment where we need experimentation and we need contrasting and in many ways complementary ideas, as you pointed out. And so what I think I would love to see is a sort of reframing of states as laboratories of democracy for states as laboratories of innovation, right? Because right now is the moment where no one knows how to answer these AI questions. And there's a lot of focus on preventing AI's harms, which I do think is warranted in many contexts, but perhaps should not dominate the legislative agenda, because AI, in my opinion, is an inevitability. We are going to see more and more investment in these tools. We are going to see it take over more and more aspects of our economy and dictate more and more national security decisions and so on and so forth. And so my guiding star here would be, how do we really pursue AI readiness? And I think that question of how do we build more resilient systems such that folks are prepared for the jobs of the future require 50 states to really go about this piloting effort and to see this modularity of being more honest about the fact that we don't know what's going to work as intended. So how can we see contrasting values of, all right, what is the right floor of rights as and benefits that you established? What are the right sorts of disclosures we can see between employers and employees or laborers, and how does that impact negotiations? All of these things, I don't have the actual answer to, and I'm based off of your very nuanced and thoughtful remarks, I'd venture to guess that you would also say you're not exactly sure how to perfectly calibrate these things, and so
Absolutely right.
this is where we should see really robust measuring of just seeing how does this actually impact how workers are being trained, where they find new jobs, where they find new opportunities. But what I love about this conversation too, and about this opportunity, is I think everyone acknowledges, and well, my hope is that the status quo really isn't great. And if you accept that, if you accept right now, we live in a low hire, low fire environment where I'm guessing everyone in this room has someone who says, I hate my job, but I can't leave. That's a real bummer, right? We should aspire to do better. And yet I'm guessing that everyone also has somebody in that sort of position who says, I would love to move to city X or state Y, but you know, my mom lives here and my grandparents are here and I don't know if the schools are good enough over here. We don't have the sort of go west young man mentality that has been our sort of economic engine for the duration of this bold American experiment of saying, go and find new opportunities. That's the sort of entrepreneurial spirit that I think we need to encourage, and which I think both of us agree amending the FSLA can help facilitate that. And so now it's just a matter of going and trying it. But I worry that the sort of hesitancy to get over that initial threshold of, oh, we actually do need fundamental change, not just small tinkering, is really what's going to hold us back.
I agree with that. And I have some vignettes that show how, how your ideas work and how I would see it maybe slightly differently, but they all would come out to very similar solutions. If any of us want to hear any of those vignettes, but I did create a few vignettes for that. But I'd rather hear your questions rather than me speak more about what I was thinking. So I think we should just open it up.
Let's
to
do
questions
it.
at
Let's
this
do
point
it.
then.
Yeah. We got to get Zach some steps.
Thank you. So Professor Lofaso, how would you respond to the idea that the type of enhanced regulation that you've kind of talked about would hinder AI innovation or make companies kind of more hesitant to move forward with that in light of the potential for increased labor costs or the problems that it could cause for companies?
Yeah, that's always the argument, right? That when the government steps in, it hinders innovation. It's, but there's the law has a role to play, and it's why we have public discourse. So we would add that in, that we want innovation. Obviously, we want innovation, but we heard. I mean, I was really scared after I actually study AI. I'm not a rock star like everyone else here, but I study AI, and I was scared by hearing what the first speaker spoke about. So we obviously need regulation to protect ourselves. So that's always the argument. The trick is getting our legislators, and I don't mean the state legislators who are absolutely wonderful here in West Virginia, okay? I mean we need to get our federal legislators to actually function. They're completely dysfunctional right now. And they're not, what the problem is that, in my view, is that everyone thinks like they're on Team Red or Team Blue instead of Team America or Team Human. And here's a problem, we need to solve it. So people get angry. I think what you saw here is we're not angry at each other. We're actually really interested in each other's ideas, okay? Now, I said that something he said was fanciful. What I said is also fanciful. Okay, you want to be truthful, which is that there's a lot of people that don't like the idea in this country of anything that sounds collective, okay? That's a problem because when you have community and collectivity, you actually can often have more economic efficiency. But somehow we've been trained to think that means it's taking away our autonomy. Well, whose autonomy is it really taking away? Is it not enhancing our individuality? So, but we don't even have these nuanced debates because we're Team Blue, Team Red, rather than Team Human, Team America, here's a problem, and I don't get everything I want, you don't get everything you want, but we get something that will solve this problem.
And just a small thing to add there would be the status quo is incredibly expensive to employers right now. The litigation costs of having to anticipate and then defend FSLA claims. If you can provide regulatory clarity in either of the ways we set forth, you're going to cut back against those costs of trying to anticipate and get ahead of that litigation. So that in some way can save some funds in terms of not thwarting innovation. I'd additionally add that AI is wildly unpopular. You may have heard that AI had a favorability rating lower than ICE.
No, that's impossible.
That is, I should call the folks at NBC and let me know. Yeah.
I believe you.
So AI companies don't really have a social license right now to do anything. And so they need to find good signs to show, hey, we actually care about the future of work. We care about the future of the economy. And to say that, hey, we want to engage and assist with this new experimentation that we've been discussing, I think would actually go a long ways with people. Because right now, it's not wildly helpful every time one of those tech CEOs comes and says, yeah, 5 to 10 years, your jobs are gone, we'll figure it out. That's not great. But if you can get behind actual solutions and proposals, I think that goes a long ways with folks.
All right, thank you. Any other questions? I know Professor Frazier is open to answering anything AI related, so.
Thanks. Thank you for your presentation today. It's very interesting. This goes in the category of anything AI related.
Let's go.
You mentioned that AI is inevitability, of course. A lot of us practicing law are trying to figure out like, how can we really use this? But, you mentioned, well, try Harvey and try Learned Hand. We're concerned that the minute we put any confidential information in that we're subject to a bar complaint and ethics violation. So can you just tell us, in your view, the top 3 concerns from an ethics point of view, what we need to watch out for? Obviously, I'm not asking about hallucinations, like that's very 2003, right? But like today, what are the things that attorneys need to be aware of, and what should we be mindful of? How should we be careful so that when we use these tools that are changing? I've never heard of Harvey until today. I never heard Learned Hand until today. I've heard of a lot of other options. So can you help us in that regard? And well, we will pass that on.
Yeah, I'd love to. That's a fantastic question. So first and foremost, I think that the concern about client confidentiality can really be mitigated by the use of these bespoke AI tools. So Harvey, for example, it would be an existential threat to their business model the second that there is a bar complaint that's filed against them for divulging client information. So they have safeguards such that they are never training on the information you enter into Harvey. So that is just a full stop default setting on Harvey that whatever you enter, they will not subsequently use for training. You can take additional safeguards to lower the odds, right, of having clear guidelines at your firm level about what information is entered into AI and how, right, such that if you were ever subject to a bar complaint, you can go and say, hey, here are our standard practices. Here's how we're taking precaution and proactive steps to make sure that we're not entering information that could result in an exposure of sensitive client information. And then I would also just add, be really familiar with these tools. Go into the setting feature and see what you can toggle on and off, because even with ChatGPT, folks don't realize you can go into the settings and say, don't train on my data, right? And so whereas that's baked into models like Harvey and baked into things like Learned Hand, you can also take those steps with respect to more generic tools. On a more technical level, I'd also add that the way these tools work, the odds of anyone being able to prompt ChatGPT 5 years from now and say, what did Joe from Morgantown enter in on April 9th, 2026 about client Z at this time, are infinitesimally small and are going to be decreased over time. And again, this is because market incentives. If you are OpenAI, you got a suit brought against you in 2023 from the New York Times that said you regurgitated an entire New York Times article. We're not okay with that. So if you're OpenAI now, you are investing all or a significant amount of your technical resources to make sure that you can never regurgitate that sort of client information down the road. So that, I do think client confidentiality is important. I do think the bespoke legal AI tools are taking every step possible to mitigate that, and they're doing a pretty good job. Harvey is used at 70 of the top AmLaw 100 firms. So I'm guessing they've done their homework to make sure they're feeling pretty confident about what Harvey's doing. The second, I'd say, is client disclosure of AI use. If you are billing like you're not using AI, that's a big no-no, right? So if you are not being upfront about how you're using AI to shave hours off of initial research, for example, and you've just kind of got this set it and forget it mentality of how frequently and how much you bill clients, yeah, not a good look. Could result in some real issues. My hotter third take about the thing that you need to pay attention to is most state model rules of professional conduct include a clause that say that there's an expectation that all lawyers will stay abreast of the risks and benefits of emerging technology. And the number of lawyers I have met who are not actively using AI is flabbergasting. if you met a judge or a lawyer in, let's say, 1940, who said, to bring up the remarks from earlier today, yeah, I just don't trust this whole electricity thing. Like the lights flicker, it's kind of weird. Sometimes it makes me, have headaches, and so I just don't trust it. I only write by candlelight. You say, you're wild. That is not a smart approach. You are not actively pursuing how we can do a better job for the entire legal profession. And the future of AI and its ability to contribute to access to justice issues, especially in a state that often has struggles getting access to rural individuals who can't find affordable representation, AI is a huge step change for folks. I'm from Oregon originally, and Eastern Oregon is a lawyer desert. You just don't find folks who live in Wallowa County. And so if we can collectively as lawyers think about the creative use of these tools to further the interests of justice, I think that's a mandate on all of us. And I think actively engaging with the tools is something that we all have to do.
Can I just add one thing there, which is on the market, which I agree, the market will shape it, but it does take time. So I understand your hesitancy. And so I would encourage, which is also why we want regulation, is because the market takes time to catch up. So there's going to be market failures. But one thing I would encourage you, there are also closed systems that you can use that it doesn't go all the way out and look at the search. It just does, like, it's what your husband was talking about, remember? This was at Wavila with Gina's husband. Is Notebook Google Notebook LM, which is really good. It's closed, especially if you buy the second one, is even better. You get unlimited, like practically unlimited. I listened to his talk. I did on AI. It was very good.
Thank you both so much. I have a question, but first a follow-up comment, because Kevin, it's actually even more acute in West Virginia. So of course, PR professor here, students in the room, what Professor Frazier is referring to is Rule 1.1 on competence and Comment 8, which is about technical competence. So the ABA Comment 8 says a lawyer should keep abreast of changes, including in technology. When West Virginia adopted that rule, we changed should to must. So West Virginia lawyers have a heightened duty of technical competence compared to lawyers around the rest of the country. So West Virginia lawyers, remember, we have a heightened duty of technical competence. My question, Professor Frazier, is for you, and I think I might know the answer based on what you said, but I'm interested. I love the idea of the states as the democracies or laboratories of democracy, but we are with an administration currently that wants to have federal preemption and does not want the states having their own AI laws. What's your sort of stance on that?
Thank you so much for that question, because I think it's a wildly important point, and I guess I have another 2 hours to address this, right? Because this federalism issue is one of the ones that I'm most passionate about, because what the administration has called for is preemption with respect to AI development. So for folks who want my usual go-to here is to distinguish between regulation of the engine of a car and who gets to set the speed limits and the contours and design of the road, for example. We all know that if you're driving from, I used to live in Montana, and the second you drove into Utah, the speed limit just dropped by like 15 miles an hour. In Montana, you're going 90, it's awesome, you're having a great time, and then all of a sudden you're going 65. We're fine with that distinguishing factor between the states because Utah's deemed it safer to go 65. Montana says you need to get to wherever you're going as fast as you can, go for it. That's fine because it doesn't change the behavior of out-of-state residents, right? And it doesn't change how the car is designed. It doesn't change anything about the fundamental technology. Now, imagine if Utah had a regulation that said, before you Montanans drive into Utah, you need to switch your engine. Well, all of the sudden that becomes wild, right? Because you get to that border, you have to pull off, you got to hire this mechanic, you have to train, put the engine back in, so on and so forth. It's absolutely bonkers. So AI development right now is akin to that engine of these models. To train an AI model, the development stage of this process is billions of dollars and multiple months to take place. This training is the collection of all that data, the use of machine learning to then train that model, refine that model, and then make it generally available. If even two states have different ways of designing that engine, so to speak, then you run into an impossibility because not even Google, not even OpenAI, not even Anthropic have enough money to train 50 different models for the different states. And so that's what the administration is trying to preempt, is state regulation of model development. Now, the recent executive order, for example, has been explicit in saying that they are all right with states continuing on regulations that pertain to child safety, for example, that pertain to government use of AI, and that pertain to the enforcement of existing laws, consumer protection, fraud, discrimination. And so really what this boils down to is distinguishing who has regulatory authority with respect to AI development and who has regulatory authority with respect to AI deployment, and that's the states. And just to provide one concrete example, there was a bill in California that passed out of the state legislature that said all AI companions had to provide quote unquote factually accurate responses to minor users. Sounds pretty good, right? So all these models have to be trained in a way such that they will all provide factually accurate answers to minors. Okay, now let's get a little uncomfortable because I get to leave the stage after this, I think. Let's start with, is Santa Claus real? Okay, no one really cares. Let's just say factually accurate, no. We're okay with 8-year-olds, 13-year-olds, so on and so forth, getting that no response. Is my dad's cancer diagnosis terminal? Factually accurate, sorry, yeah, dad's gonna die soon. Okay, let's get even more uncomfortable. Did Jesus die on the cross? Now, California may have factually accurate answers to those questions. If they impose that regulation, that training tactic on how a model is actually going to respond at the development stage, then California's answers become the answers for the rest of the country. And that is exactly in tension with extraterritoriality and the ban on extraterritoriality in the Constitution. Now, this is usually the part where I go into the Articles of Confederation and tell everyone why we ditched that model of allowing single states to dictate national priorities. I'm going to leave that for another moment for anyone who wants to nerd out about the Articles of Confederation. Great. But this is the whole point of federalism, is having clear lines of where are we okay with experimentation such that out-of-state residents aren't impacted by your decisions, and where do we see states unnecessarily or improperly being able to reach into the jurisdiction of other states. And this designation of development versus deployment is about as neat as we can tie that line. Is it perfect? Probably not, but given that we're seeing AI right now being used in the war in Iran, given that we're seeing AI basically dictate the entire direction of our economy, who controls AI development is a matter of economic and national security. And again, just to briefly go back to the Articles of Confederation, this was the whole reason we ditched that model, was to say, with respect to those matters of national consequence, we have to have a federal answer. Now, I get why folks are frustrated that Congress isn't acting, but use that frustration. Call your members, right? Send an email, protest, do whatever you want, but if you want a federal answer, demand a federal answer. Don't say, oh, well, California's gonna do it for me. We'll let them go ahead and lead.
Thank you so much. Unfortunately, we're out of time.